My name is Jasmine Witherspoon, and I'm an MFA candidate in creative writing at the University of Kentucky. On behalf of the university, welcome to the main stage. We are thrilled to be joined today by a Kentucky native who is also an attorney, a professor of law at Georgetown and Yale Universities, and the former director and president of the Southern Center for Human Rights. He is known for representing people facing the death penalty, advocating for the right to counsel for poor people accused of crimes, and challenging inhumane practices and conditions in prisons and jails. In his book, The Fear of Too Much Justice, he examines injustices occurring in criminal courts today and a practical look at how they can be corrected. Please welcome Stephen Bright. Joining Professor Bright is an American journalist best known for her reporting at CNN and Forbes.com. She is an anchor of CNN This Morning and is based at CNN's New York News Bureau. Please give a warm welcome to Poppy Harlow.
Thank you. Thank you so much. It is so friendly down here. Everyone, first of all, Steve is like the star of the day, and it's an honor to be here. And thanks to everyone for coming up and saying hi and for being here. This is a real treat for me to interview someone who changed my life just a couple of years ago when I was his student at Yale Law School. So Professor Bright, thanks for what you taught me and for what you do.
Thank you for being here with us, Poppy. It's great to see you again.
I'm going to add a little bit more to that lovely introduction. Steve has argued 4 death penalty cases before the U.S. Supreme Court. He won every single one of them. He also Brian Stevenson, who many of you know of as well, the founder of the Equal Justice Initiative, calls Steve's book an urgently needed analysis. And he calls Steve the most courageous lawyer I know. He writes, Steve has taught me that sometimes you have to stand when everyone else remains seated. Sometimes you have to speak when everyone else is quiet. And that is what Steve has done since the age of 12. That is when you knew that you opposed the death penalty, 12 years old. And your work from then has been to fight for real equal justice. Went on to found the Southern Center for Human Rights, 40 years there, and then teaches at Georgetown and Yale and continues this work. So shall we begin?
We'll begin. Thank you, Poppy.
You are very intentional with the title of the book, The Fear of Too Much Justice. Those are words of a Supreme Court justice. Who and what's the context?
Sure. In 1987, the Supreme Court considered a case involving the racial disparities in the death penalty in Georgia. Pretty pronounced racial disparities. If the case involved a white victim, much more likely to get the death penalty. If the case involved a black defendant, much more likely to get the death penalty. And if it involved a combination of a white victim and a black defendant, a much more great chance of getting the death penalty. And it looked there for a moment that the Supreme Court would say, as it had said 15 years earlier, that you could not carry out the death penalty with these kind of racial disparities. But the court rejected that argument by a 5-4 vote. And Justice Powell, in the opinion for the majority, said if we deal with racial disparities with regard to the death penalty, well, we would have to deal with racial disparities in all other kinds of sentencing as well. Justice Brennan called that the fear of too much justice. And I think that pretty well explained what was going on there, but what I observe ever since then is how much it explains a lot of other things. That we're afraid to fully fund public defender offices, to give people competent lawyers with the investigative sources or resources that they need because of a fear that more people be acquitted, more cases would go to trial, really a fear of too much justice, and I think that sort of carries through with regard to the other things we address in the book.
And you write and quote Justice Powell. That was the McCleskey case in 1987. Here's what Powell wrote in the majority opinion, quote, "If we accept McCleskey's claim," which, by the way, the data showed, "that racial bias has impermissibly tainted the capital sentencing decision, we could soon be faced with similar claims as to other types of penalty." And in his dissent, Brennan was so stunned by that he just said, taken on its face, such statements seem to suggest a fear of too much justice. That was 1987, now 2003, and the four words above the Supreme Court still are
equal justice under law, right?
And do we have that?
No, and I think that unfortunately, the longer we go, the further apart we get. In the early 50s, the Supreme Court said in a case, there can be no equal justice, basically the same thing. There can be no equal justice when the kind of justice a person gets depends upon the amount of money they have. I think today most people would agree nothing matters more in the criminal courts than the amount of money a person has. A person that has money is going to get out on bail, is going to hire a good lawyer, is going to contest the charges in a way that a poor person who may be arrested and languish in jail for weeks or months before they even see a lawyer, and often does not receive any more than very perfunctory representation. There's quite a difference.
So that was 1956.
Yes.
And that was Griffin versus Illinois. Again, there can be no equal justice where the kind of a trial a man gets depends on the amount of money he has. But it is still that way in our system.
Yes, as I said, I think today that the amount of money one has, I mean, particularly today, cases are complicated. You need expert witnesses, you need investigation, you need social workers. There are a lot of things besides just simply having a lawyer, but you also need a lawyer that has a reasonable workload and has the resources to determine the strength of the prosecution's case, to see what kind of defense case there may be, to take the fight to the prosecution. And unfortunately, a large number of people accused of crimes in our society today just don't have that.
One of the things that Professor Bright said to us in class and subsequently when I've interviewed him for CNN, and he often says people are always much more than the worst thing they've ever done in their life. There is a story behind every defendant, and so I think it's very appropriate that you open the book with a quote from Winston Churchill. This is 1910. He's addressing the House of Commons, and here's what he said then. "The mood and temper of the public in regard to the treatment of crime and criminals is one of the most unfailing tests of the civilization of any country. A calm and dispassionate recognition of the rights of the accused against the state, and even of convicted criminals against the state, a constant heart-searching by all charged with the duty of punishment." He goes on to say, "and an unfaltering faith that there is a treasure, if you can only find it, in the heart of every man." That there is a treasure in the heart of every person, even murderers. And you have always defended indigent. You have always defended people with no other resources to be defended. Why did you open with those words, and how do they resonate today?
Well, I think there's so much demonization of people today and denial of the humanity of people, and I think what Winston Churchill recognized, and there are other great thinkers through time who recognize that what we say, that there's more to a person, the worst thing that they ever did, and of course I've seen that, lived out so long. There are people I represented at one time when they were, waiting execution. And as you and I both know, my friend Tony Amadeo is my client, whose case I argued in the Supreme Court. But last summer I went and saw him. He runs a ranch in Texas now. And he's a very useful and productive member of society.
Well, let's talk about the case of Tony Amadeo. That was your first case before the Supreme Court.
Yes.
You write about it in the book, and it was 1988. You won. The Supreme Court overturned his death sentence, and in Justice Marshall's majority opinion, he explained the underrepresentation of blacks and women on the master jury list was engineered precisely to avoid a successful statistical challenge. What I find interesting is that Tony Amadeo was not a minority, nor was he a woman. So explain why Tony Amadeo is white, why that makeup of the master jury list mattered in his case and how you won that case.
Well, anybody, no matter what their race, is entitled to a jury that's a fair cross-section of the community, and is entitled to a jury that was not selected by discrimination against any group of people. We found out after Tony was sentenced to death, and this is an interesting little commentary on the death penalty in Georgia. This crime took place, a man was robbed and killed, and 3 people who had gone AWOL from the Marines were charged, including Tony. 2 months to the day after the crime, Tony went on trial on Monday and got the death penalty on Tuesday. His co-defendant went on trial on Wednesday, got the death penalty on Thursday, and on Friday, the other defendant who had testified against the other 2 pled guilty and was sentenced to life in prison. So they disposed of 3 death penalty cases in 1 week. And some substantial time after that, we found out that the prosecutor had written a memorandum to the jury commissioners telling him to underrepresent blacks and women by 10% in the jury pools, so that if anybody tried to bring a statistical challenge, the Supreme Court law was it had to be greater than 10%. So he said just underrepresent them by 10%. Of course, that was intentional race discrimination, a quota system basically to limit people. But of course, this was never supposed to be discovered. It was a secret plan. When we did discover it, we found the courts were not that interested in it. We basically, Tony Amadeo had gone through the state courts, had gone through the federal courts. He was going to be executed, and we sort of threw a Hail Mary pass, and the Supreme Court took the case and reversed his case as a result.
Tony and Steve, keep in touch. You were down there last summer. You'll be there again. He wrote you a letter that I read. I'm sure he's written you many letters, but one line that struck me is he wrote that every day I count my blessings. God bless, and again, thanks for my life. What is it like to receive a letter from someone whose life you have actually saved?
Well, of course, I'm very happy for him, that's for sure. And Tony's been a great example of the point that we made earlier of just what, redeeming value people have. I mean, he's someone who's no question, he's guilty of the crime, very remorseful for the crime. Has spent his whole life trying to atone for the crime and make the best he could of what life he had left. And he graduated summa cum laude from Mercer University. He went to Texas, where his family was, and as I said, he now runs a ranch in Texas.
But there are people all over this country, perhaps in this audience, who just don't agree with you, and they believe people like Tony Amadeo don't deserve the best representation that you represent. Victims' families who've lost their loved ones who don't believe that that is justice. And I wonder how you reconcile that.
Well, I think a big part of what I've tried to do the whole time, we talk a little bit about it in the book, is achieve some reconciliation from those who are victims, those who've been harmed, and those who've been responsible for the harm. Because I think that's the way forward. And I think that we've seen that in a number of cases, and it's worked out really well, including cases of mine. But we also see many cases when there's a great deal of demagoguery, and there's a great deal, as I said, of demonization of people. But sometimes we just have to try to figure out, because if we want to keep things from happening in the future, we need to figure out what happened last time.
You intentionally opened chapter 1 of the book with the story of Glenn Ford, and this is along the same lines. At Louisiana, I think 1984, does not have experienced criminal lawyers at all in terms of defense, also an all-white jury. Why did you open with his case? What happened to Glenn Ford?
Well, I think Glenn Ford is particularly interested because the prosecutor in that case, this was a man who spent 30 years on death row in Louisiana, turned out to be completely innocent of the crime. The state admitted as much, that they did not have a case against him, so he's released, as I said, after 30 years. Unfortunately, by then he had stage 4 cancer, not helped in any way by the poor quality of health care in the Louisiana prisons. So he died just a short time after getting out of prison. But the prosecutor, the person who sentenced him to death, wrote a letter to the community, carried in the Shreveport newspaper, Shreveport, Louisiana, in which he apologized for putting this innocent man on death row. And he said, at the time I tried that case, I was young, I was narcissistic. The only thing I cared about was winning. It didn't strike me as terribly unfair that Glenn Ford was represented by two lawyers who had never tried a case before. It's in a death penalty trial. One of the lawyers was an oil and gas lawyer, and the other lawyer was a slip and fall lawyer. And those were the lawyers. And he said it also, I didn't think it was that bad that I struck all the blacks in jury selection, so he was tried by an all-white jury and sentenced to death. And I think what the prosecutor said there sort of pulls together several of the themes that we have in the book, is that sometimes when people are young and narcissistic and only care about winning, that they take one tack that maybe upon reflection later on they may have a different view about it.
If you look at the data from 1973 to 2020, 185 people in this country who were on death row would later be exonerated. So those are the kind of numbers that we're talking about. I also want to talk about a case that struck me so much learning from you, that is not a death penalty case, but it's about the lack of sufficient representation, which is a theme throughout the book, and that is a young woman named Shauna Shackelford. She wrote this letter to Steve, and I'm going to let him read a little bit to you, but the context is it was in our materials in his class, and I read it as part of our assignment one day and started crying, and I immediately emailed him, and I said, well, what happened to her? Because you didn't include what happened to her. And then subsequently, I'll let him tell you her story and what happened to her, but what she represents. So here is this letter called A Plea for Help.
I get a lot of letters like this. This letter happened to come right before graduation in 2016. And so I read it in my commencement speech at Yale Law School. It's a young woman writes me and says this: I am currently have a first-degree arson case pending in a Superior Court in Georgia. And after I was indicted 6 months after my home burned down. And I answered the charges immediately, and I applied for a public defender. The lawyer I got was incompetent. And she goes on about that to some length. And she talks about how she would go to court, and half the time her lawyer wasn't even there, so they just put it over for another hearing. And how her lawyer wanted her to plead guilty, but she didn't want to plead guilty. And she finally writes to me and says this: I have no place to go. I'm a certified nurse's aide, but I can't find employment because of these arson charges which are hanging over me. I don't know how to fix this. I've asked to be placed in jail until this is over. I don't want to sound ungrateful for being out on bond, but because I fear I may take my own life, or I may just die from the conditions of being homeless. Even my request to be sent to jail was denied as well. The last offer was 10 years probation and restitution. And I told my lawyer, absolutely not. I told him that there will never be a time I will never accept the blame for something I didn't do, because a guilty plea, even if I don't go to jail at all, will ruin my life more than this case has already. I will never be able to use my degree in nursing, and I will never be taken seriously. She wound up saying, I've had over 20 continuances. I've lost my job, I've lost my home, I've lost my dogs, I sleep in my car, and now I am about to lose my car because I can't make the payments on it. I am tired and I am beaten, and I don't understand what I do next. Just happened that the judge down in the area where she lived had resigned from office. Hanging judge who'd been on the court for a long time, and the Journal-Constitution called me and said, what do you think? Judge Lee has resigned. I said, it's 30 years too late. But she happened to see my name and looked me up and sent me a letter.
And what did you do?
And I said to my students, of course, when you tell your students this, they all say, all right, I'm on board, sign me up, how can I help? And so we took Ms. Shackelford's case, Palmer Singleton and I, one of my other lawyers, we realized we didn't know that much about arson cases either, but we knew to do this. We contacted a leading lawyer in Atlanta who represented insurance companies and had litigated many arson cases, who then put us in touch with John Lentini, the absolute lead expert on arson, wrote a huge book about it. We paid $200 for the book. And brought him in on the case, and before long we were able to demonstrate that, contrary to the government's theory that the fire had been started in the bedroom by Shauna, that in fact there was electrical problems in the ceiling, and that's where the fire had started. And the prosecution, once we presented that to them, dismissed the charges, and she was able to go on with her education and her life. The problem was, the little public defender office there in her hometown had no idea how to try an arson case. And they didn't know to reach out for somebody that could be helpful. There's no telling how many people have situations like this that never know who to write to or never get an answer from the letters they write. This one case, we were able to step in and help her out.
And we were able to meet her last year down in Georgia. We met her together. She has a little son. She runs her own business. But for Steve, she would not. You often tell your students to work in a public defender's office and be proximate to the need. What do your students find when they go to court?
Well, one of the things we did the time I was at Southern Center for Human Rights is we knew how terrible people were being treated in court. So we sent people out to court all the day. Go to this court, go to that court. See what you can find out, count the constitutional violations, and come back and tell me about them. And I'll just tell one story, Poppy, which was one of our actually undergraduate interns was from Dartmouth College and was down with us, and we sent her down to a courtroom, and she ended up going to the jail, and they told her at the jail, you need to talk to a man named Samuel Moore here at the jail. And so she talked to Mr. Moore. He had been in jail for 13 months. He had been arrested 13 months earlier on the charge of loitering. You've heard of driving while black. Loitering is standing around while black. He had been arrested for standing around, thrown in jail in 13 months. He had never seen a lawyer. He had never seen a judge. When Atia went to the clerk's office to find out what was going on in his case, it turned out the charges had been dismissed 4 months earlier, but nobody had told the jail, you no longer have any legal authority to hold this man in jail. So this Dartmouth intern tells them, you know, he's still in jail, and they send word to the jail, and he's released. That's how deficient the system was, that a person could get arrested and get lost in jail and be there for 13 months. We found other people that had been there for 7 less months. Never been charged, never seen a judge or a lawyer.
I want to spend a little time talking about what I found to be one of the most powerful parts of the book, and that's the power of prosecutors. It's also what was most interesting to me out of our time together in your class. On page 47, you write, the prosecutor is clearly the most powerful actor in the criminal justice system, and you open chapter 2 quoting former U.S. Attorney General Robert Jackson, saying, well, the prosecutor at his best is one of the most beneficent forces in our society. When he acts from malice or other base motives, he is one of the worst. He also went on to say the prosecutor has more control over life, liberty, and reputation than any other person in America. That is certainly not how I thought about it at all before taking your course and learning much more about prosecutors. You go as far as to say prosecutors run many trials, not judges. How?
Well, I'll give you the example I think we lead with in the book is a couple of women who were facing the death penalty in Georgia. Both of these women were two people charged with a murder. The first one was Kelly Gissendanner. She and her boyfriend had conspired to kill her husband so she could collect the insurance and run off with the boyfriend. Tragically, those things happen every now and then, and they're terrible. What happened was, after they were charged, the prosecutor told them both of them, if you want to plead guilty, and testify against the other. If need be, you can be sentenced to life in prison, eligible for parole after 25 years. And the boyfriend took it in a heartbeat. Sign me up. I don't want to get the death penalty. I'll testify against her. You know, well, no matter how I may have felt about her then, not now. Ms. Kissendatter said, well, I want to be eligible for parole after 20 years, not 25. Of course, the fact you're eligible doesn't mean you get it. It just means you're eligible. And based on this quibbling about when she's eligible, when she's not, the case goes to trial. She's sentenced to death. And the prosecutor says in closing argument, you know, some crimes are just so bad that they require the death penalty. But of course he knew better, because he had offered her life in prison. He even offered her life in prison eligibility for parole. But because she didn't take the offer, she paid the price. She was sentenced to death. By the time 15 years later that it came time for her to be executed, she had been a model prisoner. The two children of the marriage were desperate to try to prevent the execution of their mother. The Pope, the Chief Justice of the court there in Georgia, all these people said, please don't carry out the execution. But she didn't take the deal. And the trial penalty, as we talk about with regard to not only death cases, but other cases, if you don't take the deal, you pay the consequences. And she was strapped down, and she was about halfway through the second verse of Amazing Grace when the lethal drugs took her life. Another case very similar to that. So that's the power of prosecutors, whether to seek the death penalty or not. Never has to be sought. But can be sought in the southern states, whether to plea bargain the case or not. That's where most cases are resolved, and that power is, and of course the one other power I'll just say quickly, prosecutor has the only person in the system who can reward people for testifying the way they want them to. You testify for us, we'll dismiss your charges, or we'll give you a lesser deal, or whatever. Nobody else can do that, right? Defense lawyers can't do that. No other lawyer can do that. But the prosecutor can reward witnesses with dismissing charges, reducing charges, paying them money, all sorts of things like that, which certainly is an awesome power which influences how criminal cases come out.
There are also prosecutors who use that power very differently, judiciously, for good. I think my colleague at CNN, Laura Coates, who we both know, just wrote a book called Just Pursuit, and she worked at Maine Justice. And so I'm interested in, because you write that over 90% of criminal cases are resolved with guilty pleas. I'm interested also in the power of the prosecutor and the issue of so many plea deals, in not a capital case, but a Kentucky case, Paul Hayes. This was so striking to me when I learned about it, and then you write about it again in the book. This is about an $88 check. What happens to Paul Hayes?
Right. I always tell people all you need to know about plea bargaining is Paul Hayes, right here in Kentucky. I expect Ed Moynihan has something to do with that case. $88 bad check. How bad is that? What should you be punished for with that? And the prosecutor said you can have 5 years, which seems to me like an awful serious sentence for a bad check for $88. $88 is a little more back then maybe than it is today. Nonetheless, Hayes says, no, I want to go to trial. I say, if you go to trial, we're going to file papers so that you get life in prison for a bad check. Hayes goes to trial, gets life in prison. Case goes to the Supreme Court of the United States. They say, surely it can't be right that if you go to trial, if you exercise your constitutional right to trial, you get life in prison when you would not have gotten but 5 years otherwise. Supreme Court said, nope, that's the way the plea bargaining system works. And of course, this is what we see all over the system, not just death if you don't take the deal, but you'll get 20 years if you don't take the deal, but if you take the deal, you get 5, or you get out today in misdemeanor cases a lot of times. If you plead guilty but you go to trial, well, first of all, you'll stay in jail 6 months before the trial. And that's why a lot of innocent people plead guilty, because you want to get out of jail. But that trial tax, that is that penalty that people get for going to trial, is an awesome power which prosecutors have. And you're right, there's some that are exercising it very differently. That's the other thing that's very impressive, is how different it can be from one judicial district to another, how prosecutors exercise their power.
And also the power of state legislatures. For Paul Hayes, it was a habitual offender law in Kentucky at the time that even the Supreme Court in that decision said, acknowledged persons convicted of rape and murder are often not punished so severely. The Kentucky legislature changes the law to I think a mandatory 10 or 20 years, but that doesn't, but
they
not
had
retroactive.
changed the law by the time Paul Hayes got to the Supreme Court.
But it didn't.
But it didn't help him.
But Steve, we don't have the capacity as our justice system to try all these cases.
Right.
So don't we need plea bargains? What do we do?
Well, I always say this. Most cases, whether civil or criminal, settle. That's because a lot of times it's pretty clear what the outcome is. But generally, settling cases involves each side giving up something in order to make, the prosecution wants to avoid the risk of an acquittal, even though it might be unlikely. The defense wants to avoid a more serious sentence for a less serious sentence. But the ability to do what was done in Hayes' case and have such draconian punishments, which is so common today, that literally, somebody would get probation if they plead guilty, but they get 10, 15 years in prison if they don't, causes a lot more cases to be resolved with plea bargains than ought to be.
One thing you talk about in the book, I don't know how many people know this, I don't think I knew this before law school, that it's unique to the American justice system that we elect our prosecutors.
Only country in the world.
What role does that play in what you believe is not a just system?
Well, when I went to Georgia in 1982, there were 3 or 4 prosecutors, including the one who prosecuted Tony Amadeo, that their whole identity in life, their whole political identity was the death penalty. Any time a case came in that was a potential death penalty case, they sought the death penalty. And they ran on the death penalty. And they were tough on crime. Johnny Holmes in Houston, when he was the prosecutor in Houston with Harris County, he was getting 10 or 11 death sentences every year. That's more, every year. That's more than some states like Kentucky impose in a year. Harris County has carried out over 130 executions, more than any state except Texas itself. But that's part of the sort of politics of crime. That's changed to some degree now, but that's certainly what it has been over the years.
But I think proponents of elected prosecutors would say you're giving the public a voice. Why is that not the right way?
Well, one thing is, of course, mostly prosecutors have been very down ballot elections and nobody's paid much attention to them.
But isn't that our fault?
Now, well, of course, but that doesn't mean it's a good idea to do it,
What's a better way?
Well, I think merit selection of both judges and prosecutors is a much better way to go, and it's what we see in other parts of the world, and we do see in some states. Not everywhere, but Connecticut, where I spend a good bit of time, prosecution is a civil service job. It's not an elected job. People move up through the ranks and that sort of thing. But in most states, it is elected, and as I say, it means that I used to say this. At one time, the prosecutors in Houston were seeking the death penalty all the time. Case would be a death penalty case in Houston, but that same case would not be a death penalty case in Dallas or anywhere else in Texas, in Austin or anywhere else. But now there's a different prosecutor, so a case that was once a death penalty case in Houston, it's not even a death penalty case in Houston anymore. And in Philadelphia, where for many years there's lots of death sentences being imposed, and then Larry Krasner runs for district attorney. He says, if I get elected, I'm not going to seek the death penalty.
In Philadelphia.
Philadelphia, yeah. So in the 6 years he's been there, not a single person. So you have a jurisdiction that went from a lot of people, over 100 people sentenced to death in the terms before Krasner, now nobody being sentenced to death at all.
Larry Krasner is an example of a so-called progressive prosecutor.
Yes.
But there are a lot of folks in this country who do not support what progressive prosecutors are doing. They look at crime numbers and they make a correlation. And I wonder what you say to critics of progressive prosecution.
Well, I think that, again, I think it goes back to the whole election question to begin with, because we ought to make criminal justice policy on a, we ought to be smart on crime, not just tough on crime. And unfortunately, we very often have people who have one agenda or the other, which is not necessarily the ones of making sure that we're doing justice in the criminal system.
You also write about elected judges.
Right.
And what was interesting to me that I learned from the book is, the former Supreme Court Justice Sandra Day O'Connor, conservative justice, worked tirelessly in Arizona against that issue. She saw real issues with it and all of the money surrounding it, and sounded the alarm about it. Talk about the issue of elected judges as well.
Sir, yes, and Sandra Day O'Connor, before she was on the Supreme Court, developed a merit selection system that was employed and is employed to this day in Arizona. People thought that might get around to some other places, but it really didn't. And then after she left the Supreme Court, she sort of dedicated her life to trying to bring about the same thing in other places, but unfortunately not successful in doing that. But when I first started doing this work, one thing that we were seeing all over the country was that judges would be voted out of office because of what happened in a single death penalty case, or in some cases, several death penalty cases. In California, the governor said if the California Supreme Court justices kept upholding, reversing death cases, he was going to have them all removed from the bench, and he campaigned against them, and 3 justices are voted off the bench. And they're replaced with very, very conservative pro-death penalty judges. We saw the same thing in Tennessee with Penny White, voted off the court there. Mississippi, people voted off the court. And before long, it becomes clear that if you want to stay on the bench, you better not reverse a death penalty case because you're signing your own political death warrant when you do so. And of course, we want to do 2 things. We want to figure out the best way to select the best judges. That's critical. But secondly, we want judges, once they're in office, to have the ability to decide cases on the merits, decide cases based on what does the law require, not based on can I get reelected. And unfortunately, I think even some pretty strong-willed people found it just impossible to do the right thing in cases because of their political aspirations.
You dedicate a really important part of this book to mental illness, specifically as it relates to those on death row and those who have been convicted and sentenced to death. Ricky Ray Rector is the first case we learned about in your class. There's also Andrew Thomas is one example. You also write about Joseph Carl Shaw. Talk about that in totality and how our system as it stands now considers mental illness when considering the death penalty.
Yeah, I'll just use one example, which is Andre Thomas, who's probably going to be executed in the next little bit in Texas. This is a man, normally the age of onset for schizophrenia is late teens, early 20s, somewhere in there. This man was hearing voices when he was a child. And at some point he read in the Bible, if your eye offends you, pluck it out. And he gouged out his eye. Later, after he had been sentenced to death and was on death row, he apparently read that verse again and gouged out his other eye and swallowed it, ate it. So this is a man who's pretty profoundly mentally ill. He killed his wife and 2 children, thought that he'd been ordered by God to do it, and he cut out their hearts and put them in different bags and did all sort of really, really bizarre things. This is a really sad, tragic case, but the state of Texas sought the death penalty on the case. And he was tried, Andre Thomas, a black man, tried by an all-white jury, and he was sentenced to death. And although he's been in a mental health unit just about the entire time that he's been under death sentence, the state of Texas wants to carry out his execution. And I think that's just, what do we really accomplish by killing somebody that's that disturbed and that troubled and is living such a sad life as a result of that. The other thing I'd say about mental illness, though, is all the people at the other end, the people who are the homeless people, the people who are, arrested for minor crimes and are put in jails and prisons. The largest mental institution in most communities, every community I think, including this one, is the local jail, because all these folks that we're not dealing with in terms of their mental issues and so forth, we're dumping in jail.
But there's some hope on that front. What
There is.
Miami is doing is an example. California just passed a controversial new law as it relates to those services for the unhoused. Talk about what Miami's doing.
Well, Miami just shows what can happen when you have visionary leadership. A great judge there who saw that these mentally ill people were cycling in and out of court all the time. They're in court, you put them in jail for 6 months, they get out, they're in again. And so he started dealing with it, and among the things they did is, first of all, they started having mental health training for every single police officer in Miami and Dade County, whether you were in the main police department or whether you were in the school police department. And they trained all of these people in all these ways of de-escalating, avoiding some of these great tragedies we've seen of mentally ill people being killed by the police. But most importantly, they were able to divert the jail population decline from about 7,200 to about 4,200. Saved an incredible amount of money in terms of jailing people. And then they built this really state-of-the-art mental health facility to provide housing, to provide mental health care, to provide dental care, medical care, all kinds of things to try to avoid putting people who are mentally ill in the criminal courts at all and in the jails and prison. It's been a tremendous success, very costly, but it's what we ought to be doing everywhere.
So we have a couple more minutes, and then I do want to open it up for questions. So if you have a question, think about it, and then we'll get to you next. I know Professor Bright would love to hear from all of you. When reviewing your book, The Guardian begins by writing this. When Stephen Bright takes on a new death row client, he makes him a promise. He pledges to stick with them all the way, and he means it. 5 times now, he has gone with a condemned man into the death chamber. And I wonder why you go to bear witness.
Well, I think what attracts one to doing this work is being there for people when they're in court, when they're alone at the bar of justice, and I think people need somebody to be there for them all the way to the end.
And you never leave.
No, and it's important, I think, to go to talk to mother or family or whoever and talk about those last few minutes and talk about, whatever you can say to provide as much comfort for them as you can provide, and that's an important thing that you do.
This is Professor Bright's first book, and I've asked him a couple times now, why didn't you let anyone write a book about you? This is a book about the work. Or why didn't you write a book about yourself? You've had an extraordinary life. And you, in your humble way, think, well, I'm not that interesting, and I haven't done that much. But there are a number of people that I have heard refer to you as the saint. And I wonder what you think about that.
I don't know who they're talking about.
I think that captures the man for you. Do we have any questions? Right here. Do you want to bring me up? Hello.
Thank you. You sound really busy. What's your writing process? How did you pump this out?
Oh my, I wish I hadn't asked that. I write a lot of briefs, I've written a lot of articles, and most of those I've ripped off and done them and kept running. But when I started working on this, it was a much slower process. I'd give my students research and come back. The long and short of it is at one point, one of the students in my class, James Kwok, who had been in my class when James was in my class at Yale, somebody mentioned to me one day on the way to lunch, said, by the way, did you know James has a book on the New York Times bestseller list? I said, no, I didn't know James had a book, period. But at any rate, he did. He's an amazing person. And at some point, he and I decided to work on this together, and it's enormously helpful because we could just send it back and forth to each other. Most of what's in this book is what I saw while I was in the South, 40 plus years of doing this work. But what James brought to it was also we have to document everything with our footnotes and things like that, and the writing and all that. So it was a very good collaborative process, and I haven't cringed about anything so far that's in there, so I think it's okay.
We have another question right here. If you'll stand up, please.
Steve, I wonder, have we made any progress in getting rid of cash bonds nationally? Getting rid of cash bonds. I know there's some movement in other states to limit cash bonds. How are we doing nationally on that?
Well, cash bonds, for those that didn't hear the question, a lot of people arrested, cannot pay. They may only have a $500 bond, but if you don't have any money, $500 might as well be $5 million. Just recently, 2 weeks ago, I think Illinois did away with cash bonds completely. So that's a big step forward there. We saw a case out of Houston that greatly reduced the use of cash bonds. It was upheld by the Fifth Circuit. That's one of the reforms that is making progress, but we have a long way to go. But I think we're making progress there. Illinois leading the way.
Hi, Mr. Bright. I was wondering, what is the one piece of advice that you would give an attorney walking into a courtroom defending a client facing the death penalty?
The one thing, well, I think the most basic thing is lawyers have to care about their clients because that motivates you to do so many other things. And unfortunately, what I've seen over the years is a lot of people who were represented in death penalty cases by very uncaring lawyers who were more interested in the money they would make from doing the case or staying in the good graces of the judge or the prosecutor than doing what it took to represent their client.
So that's antithetical to how some attorneys feel that you have to keep some distance between yourself and a client. You and Brian Stevenson believe you have to let your heart break for them with them.
Yes.
Why is that the right approach?
Well, I just think, again, I think that's it's your motivating factor, but I got involved in this work not because I was interested in some abstract legal process, because I cared about people and about people being killed, and I wanted to do everything I could to keep people from being killed and being sent to prison or being sent for too long or whatever it may have been. And so, you know, my identity is really with the work and the people and doing what I can for the people that I represent.
Right here.
As a retired trial judge, I have had the experience of presiding in some death penalty cases, and actually I set aside a death judgment once in post-conviction relief case. But two observations I would make, and I think you would agree with these, Professor. Until we substantially reduce the incidence of racism in this country, we don't need a death penalty. There's just no way a death penalty law can be consistent with justice in the kind of way that we like to think of the justice system in this country. And the second point I would make is politically the most sellable reason to eliminate the death penalty would be its inefficiency. It makes the whole criminal justice system much less effective and efficient, and I look forward to reading your book.
Thank you.
I was going to say thank you, Judge, very much, and if you want to speak to that
I'll just
issue.
say two things very quickly. You're absolutely right on both counts. The first count on the race relationship, the death penalty is viable today only in the former slave states. Almost, you know, long before the Civil War, Michigan, Rhode Island, Wisconsin had already done away with the death penalty. But the southern states, well, you have a slave population. You got to have the death penalty to terrorize the slaves and to punish them. And since the Civil War, you know, the death penalty is today, Texas, Alabama, Florida, all the death sentences are being imposed and carried out in the former slave states. And on the second point, yes, the amount of money and time and consternation that goes into capital cases. The New Jersey Commission, which studied the death penalty in New Jersey, said costs too much, takes too long, re-victimizes the victims, and we're really not killing anybody. So why do we have this enormously expensive penalty that really isn't accomplishing anything? That same thing is true here in Kentucky, certainly, and many other states as well.
for 4 years in the 70s, the Supreme Court ruled the death penalty unconstitutional.
Right.
Why was it unconstitutional then in their view, and explain to people why that changed 4 years later?
Right, because in 1972, the justices, they sort of disagreed, but basically said it's too arbitrary, it's too discriminatory, and therefore it's unusual, it's cruel and unusual punishment. So in 1972, in Furman versus Georgia, the court struck down the death penalty, but just 4 years later, President Nixon's 4 appointments to the court, the death penalty was upheld. It wasn't much different. It isn't much different today than it was before, but the court said you could tweak the laws a little bit and we'll uphold them, and that's basically where we are today.
Poppy, we have time for one more question. And let me remind you all that please go downstairs and meet with Professor Bright. His book is there. He'll be signing. He'd love to answer questions. But for now, let's take the one last question from the audience.
What caused you at the age of 12 to make your decision about not supporting the death penalty?
You know, I cannot for the life of me tell you why. I can tell you that I was watching television. I think we had just gotten a television, and they came on and said something about somebody sentenced to death, Anderson in Kentucky. And I remember being shocked that such a primitive punishment was still being carried. It just didn't make any sense to me at all, and it never has. And I found it very emotionally sort of like, really, we're going to kill somebody in the name of the state? And I can't tell you how I got to that point, but I just had that kind of visceral reaction to it when I heard about it.
Well, thank you all for being here. Professor Bright, thank you. The book is extraordinary, and getting to learn from you has been one of the great honors of my life. So thanks very much.
Let's have another round of applause for Professor Stephen Bright and Poppy Harlow.